Hi, my name is Irini Bekhit. I'm the supervisor of the Guardianship Department here in the Surrogate's Court of Richmond County. And today we are going to be going over the process of applying for guardianship of the property only. And the most common scenario that we see for this type of guardianship is if you have a minor child, so somebody under the age of 18, who is coming into some money, meaning grandma, grandpa, or a friend left them money, or perhaps it's money that's coming in from a lawsuit. And so because they're a minor child, they can't get a hold of that money directly. And so, as the petitioner, usually the parent, or it could be somebody else, you're coming in and asking to get guardianship of that money until your child reaches the age of 18. So, what we're going to go over today is how to fill out the paperwork. I'm going to do this as if I am filling out the paperwork for my child. We're going to use Christopher as an example. So, as the parent, mom, I'm filling out guardianship for my son, Christopher, who we're going to say, for purposes of this demonstration, is getting $25,000 as an inheritance from grandma. And I have to now go to the surrogate's court and complete this paperwork so I can get the authority to get that money from the insurance company. They're not giving it to me directly unless I get guardianship authority. And then after that, we're going to go through the process. So today we're going to just focus on the paperwork. Okay. So here I'm going to share my screen with you now. And so this is the actual petition for appointment of guardian. I'm going to make sure that I fill out everything. Okay. So I live in Staten Island, so I'm going to put in Richmond. This is the petition, right? Proceeding for the appointment of guardian for. I'm going to put in my son's name. Okay. Christopher Moses. And I'm applying for property only. Why? I'm already the natural parent. I don't need guardianship of his person. So if it is a parent coming in and petitioning for their child, they're already the parent. They would only need to have property only. Now you don't have a file number yet because you haven't filed. We're going to move on to the next line, and we're going to go through this line by line so we make sure everything is filled in properly. Again, County of Richmond. Number one, the name, permanent address, date of birth, and telephone number of the petitioner and the petitioner's relationship to the infant. I am the petitioner. I am seeking to have certain relief done by the court. So I'm going to put in my name, Irini Bekhit. I'm going to put in my number. I'm going to put in the court number because I don't want you all to have my cell phone. So 718-675-8500. Okay. So okay. Address, I'm going to use the courts, I guess because I put in, oops, 675-8500. Okay. The address, I'm going to use the court's address. Again, I don't want you all to have my address, 18 Richmond Terrace. But for you, you're going to be putting in where you live, okay? So this is just a mock 18 Richmond Terrace, street and number. Actually, here we go. City, Staten Island, state, New York, zip code 10301. My date of birth, definitely not going to give you that information, but we're going to put in for purposes of this demonstration, we're going to just go with, that's my date of birth. Relationship to infant, I am the mother. Okay. Okay, now you see how the information duplicates here again, right? Name, telephone, address. That's if we have two co-petitioners. So two people coming in and asking to be both guardians. So if I wanted my husband to also be a guardian of the property to also help manage my son's property, I could put his information down. And if I just want to do it by myself, I can leave this blank. So I'm going to put in right now, not applicable. Okay, and then this whole section will be not applicable. Now we're going to move on to the next section. Question number 2. The name, permanent address, date of birth, and marital status of the infant. That's the person I'm trying to get guardianship over. So here we're going to put in Christopher Moses. Address, we're going to put in that he lives also with me at the court, right? Richmond Terrace, Staten Island. Oops, 10301, and it jumped the state. So we're going to go back and make sure everything is filled in. His date of birth, I'm going to put a fake one also. Okay. And marital, actually, he's got to be a minor, right? So we can't have it as 0, 0. Let's go with 10. Marital status, he's not of the age of 18 yet. He's a minor. That's why we're doing this to begin with. So he is single. Now, number 3, the name and permanent address of the parents of the infant. If the infant is married, the infant's spouse are this. Now here, we're going to put in more information about the parents. You're going to see a lot of this duplicates, and that's okay. Name of the father, we're going to just put in for now, John Smith. We're going to put in John Smith's date of birth. Also, everybody's born January 1st. We're going to put in 70. A date of death. Is the father alive? Is it not? Again, sometimes if one of the parent passes away and this is money that's coming into their child, it's coming in through this way. And so you would put down the date of death if applicable. And if not applicable, that's okay. Now, for purposes of my scenario, don't forget, I said this is money coming in from grandma. So the father is still alive. Permanent address. I guess I needed a, let's see if it actually takes it in. Okay. If not, then we're going to have to just, fill it in later by pen. Permanent address. Where does John Smith live? He also lives at 18 Richmond Terrace. Okay, let's go with Staten Island, New York, 10301. Mailing address, if different, it's not, so same. We're going to move on to page 2. Now it's going to be my information again, right? Name of mom. Date of birth, I think I put in, I don't know, 70, that's fine. Also, not applicable, I'm still alive. I don't think it's gonna take it because we're doing a fillable document and that's okay. So we're just gonna put in not applicable when we print this out. Address, same thing. (10301). Okay, mailing address, it's not different, it's the same. Name of spouse. Now this relates to whether or not the infant is married. So we're going to put in not applicable because my child here in this scenario is not married. Okay, number 4, the name and addresses of the adult persons with whom the infant resides if other than the parents. So for number 4, you're only going to fill this in if the child lives with somebody else. For purposes of this scenario, since the child lives with me, I'm not going to fill this part in. But let's say you would fill it in if the child lived with the grandparents. If both parents were deceased and the petitioner was grandma, she would be putting in the parental information, but now she'd be also putting in her information in this area because that's who the infant lives with. So I would put in for purposes of our mock forms, this is not applicable because again, in this scenario, the child lives with me as the mother. Okay, and then as you can see here, relationship to infant. The most important thing that we want to make sure with these forms is that every line is filled in or every section is filled in. So if it's not applicable, we write that, and if it is applicable, we fill it in. Relationship to infant, again, it's part of number 4, not applicable, I don't have to do anything. Number 5, if the father and mother are deceased, so if they're both deceased, list the names and addresses of the nearest distributees of full age who live within the state. That's because we need to know who needs to have proper notice from a jurisdictional and a legal standpoint as to who has to be given notice of this situation. Now, again, it's usually not applicable, but it could be because every family is certainly different. So in this situation, you're only going to fill in number 5 if both mom and dad, or both parents, mom and mom, dad or dad, if they're both deceased. Then who is next in line? Then you're going to fill in that section. So if it's not applicable, we're going to write down not applicable, and then we're going to move on. Number 6, the names and permanent addresses of the infant's grandparents. If not applicable, state so. If deceased, put in date of death. So here we're going to put in, and it tells you maternal grandma, maternal grandpa, paternal grandma, paternal grandfather. So we're going to put in, again, grandma, right? So we're going to put in Jane Smith. We're going to put in her address, XX, over here. This is going to let me go? No. Jane Smith, we're going to put Joe Smith. We're going to go into, I don't know, Paternal grandmother, Grandma Jones, and we're going to go with Grandpa Jones. Again, we're just filling in the information, and you're going to put in the addresses. Again, it's giving me a little problem here, but you can fill this in by hand if it is giving you a problem, or if you're using the Word document, it might be easier to fill in. But again, if there is a date of death, you want to put that information here so we know who has to, again, get jurisdiction if needed. So if they're alive, you don't have to fill anything. If they have passed away, then you're just going to put in their date of death. Number 7, please check A and B for guardian of the infant's person and property, or check B for guardianship of the infant's property only. Now, don't forget, when we started this application, we said this is going to be property only. So I'm going to just put in here because I'm trying to get authority to manage the money that's coming into my son, and I am already the natural parent. And here I'm going to put in the amount of money that I'm trying to get jurisdiction over. And in our situation, it's $25,000. Number 8, answer question 8 if requesting guardianship of the property. That's us. So state exact title of the bank account with the account number and balance, or life insurance policy number, etc., etc. So this is where we're going to put in the detail. I just noticed, right? The detail of the, it keeps making the information. So it's going to $25. We're going to make sure it's 25,000. So this is money from a life insurance policy where Christopher Moses is the beneficiary. I'm going to put in it's Grandma X passed away and named Christopher as the beneficiary. Insurance policy, let's go with Guardian insurance policy number. All right, you want to give in as much information as possible about the policy, who it belongs to, the amount, etc. Real property. This is if somebody passed away and the infant is inheriting real property, a home, land, a condo, anything like that. You're going to fill in this information. For our purposes, it's not applicable, so I'm going to put that in. Let's see if it accepts it. Annual income of infant from all sources. Is the infant receiving any money? Is the infant receiving a pension, an income from a trust, or other income? Again, this is not really applicable for our situation, but we're going to fill in as 0. State the source of the property. Where are these assets coming from? Again, it's coming from our situation from grandma passing away. So I'm going to put in grandma passed away and left and named Christopher as the beneficiary. I'm going to put in policy name and policy number and the amount of the policy. I'm going to put that in all here. I'm going to actually write it out. The infant has never had at any time a guardian appointed. That's true. So I'm going to check that off. Or if custody has been surrendered by a parent, we would put in that information right here if it's applicable. It's not applicable. I'm checking off 9A. That's all I have to do. I'm going to move on to 10. I'm going to read it. This is an affirmative statement. If the infant is a non-domiciliary married person and the petition relates to property only, that the property is not subject to the control or disposition of the person's spouse. Not applicable. I have not seen a situation yet where that provision is applicable, but you read it and see if it applies to you. Okay, now we're going to go into the background check information. Does the petitioner have or does not have knowledge that a person who's asking to be guardian or anybody in that household is the subject of a reported file with the statewide Center Register of Child Abuse and Maltreatment, or has been the subject of child protective proceedings? Again, if it applies to you, then you want to check it off. And if it doesn't apply to you, I don't have any knowledge, that either myself or anybody in my household is the subject of any of this information, okay? So you would check it off if there is. It's always better to disclose, because when we run our background checks, we're going to find out the information anyway. So always disclose, explain what happened if it's necessary and if it's appropriate. Okay. Number 12, the petitioner has completed and annexed the request for the 3909 form. You're going to get a 3909 form as well, so don't worry about that. That's part of the background checks that we do. We do two types of background checks, the 3909 form as well as fingerprints. I'm going to talk about that a little bit later. And the infant is or is not a Native American child under the Indian Welfare Act. My child is not, so I'm going to check that off. Number 14 is an affirmative statement. There are no other persons interested in this proceeding upon whom process is required to be served other than those listed above. That's why it's important to have that information filled in so the court knows who needs to be served or who needs to be given notice of this application. Again, another affirmative statement, no prior application has been made to any court for the relief requested. And now here's the meat and potatoes, right? This is now you're getting down to the bottom line of what you're actually asking the court for. I'm asking that letters of guardianship of the property only be granted to Irini Bekhit. Okay, that's basically what it comes down to. And court, I would like to have, this bank, bank ABCD with this, I have ABCD, at this address actually be the depository. Although judge, I know that you're going to be the one that's selecting that. So you can always pick a bank that you would prefer. Just as an FYI, the Surrogate to Tone, and Surrogate Giganti was the same way. They appoint local banks, and the reason we use local banks is that if there's ever a problem, we're able to call the vice president, the president of the bank, and say, hey, we have this issue. And sometimes when you're dealing with bigger banks, it's much harder to actually get something resolved. So pick a local bank on Staten Island that you're comfortable with. And again, you're picking it, but it's ultimately up to the surrogate to decide which bank he's going to approve and appoint, as well as the actual branch for the opening. So you're going to put the name of the bank. You can make up to 2 selections, and then you're going to put down the address, 123 Main Street, and the same thing, this is going to be 456 Main Street. Again, you want to fill in everything as much as possible. Okay, you're going to put the date, you're going to sign it. Now this is as you can see, there's 2 petitioner signatures and 2 names. That's if 2 people petitioned for this as co-petitioners. In the situation I'm giving you, it's only 1 person. I'm the only one that's doing it. So I would sign my name here and I would print my name here. Once I printed this out, this would have to be signed and notarized in front of a notary. I would also have this is the combined oath and designation. Again, State of New York, County of Richmond, Irini Bekhit, being duly sworn, deposes and says, this is the oath I'm taking, saying I'm going to fulfill my duty objectively, and I'm going to notify the court of any changes or anything like that. And I'm also going to designate Richmond County, this is where the jurisdiction is, of accepting process if necessary. I'm going to put in my address here again. Staten Island, New York, 10301. And I'm going to, again, sign and print. This also has to be notarized. That's actually the petition. That's all you need for the petition. Okay. Now I'm going to scroll through and I'm going to see if the next document is applicable. So, Surrogate's Court of the State of New York, County of Richmond. This is the joinder statement if the infant is over the age of 14. If you're applying for guardianship of somebody who's over the age of 18, they need to consent to you becoming guardian of the property. In my situation, my infant was only 10 years old, so I don't have to fill this in. But if you do, you would just put in the infant's name here, the infant, and again, hereby join in the foregoing petition and request guardianship of so-and-so to be appointed a guardian of my property only. So I want, mom's name of Richmond County or the address be appointed guardian of my person. So here you put mom or dad's name, whoever you want, you can put their address, be appointed guardian of so-and-so. And that would have to also be signed and notarized. The citation is only going to be completed. Usually we actually draft the citation for you, but if it's a contested matter where, let's say, it's mom and dad going against each other as to who's going to become the guardian, and so mom is petitioning but dad is not on board, like he's not going to sign a waiver, which you're going to see in a little bit, then we have to cite him. You have to give him notice of the proceeding that you're doing. Then this would be filled out. And if it is a contested matter, unfortunately, we're not allowed to assist you. You'd have to kind of fill it out yourself. But you would, again, Surrogate's Court, Richmond County, you would put in who this is going to, who has to be put on notice, and then you would fill this in, a petition having filed by Irini Bekhit, whose address is at such and such and such. The court would fill this part out, and we would basically fill this out. So you don't really have to do that because that has to be issued out by the court. I'm going to scroll through. Waiver of process, renunciation, and consent. This is an important document. This document has to be completed by anyone who is an interested party. So if I am filling this out and it's me and my husband are both the parents of this child, but I'm the only one asking to be guardian of the person of the property, my husband has to consent to that relief. So even though he's not joining me on the petition, where I'm not putting his name as a guardian of the property, he would have to consent to my relief. If he's not going to consent, he has to be cited. He has to still be given notice of the proceeding. So for purposes of this, guardianship of Christopher Moses, again, no file number hasn't been put in yet. The undersigned, we'd put in his name. I don't remember what I called him, probably John Smith. Address is at 18 Richmond Terrace, State, New York, City, Staten Island, zip 10301. I consent to the following relief. What is this person's role? In this situation, he is a parent of the above named infant. Hereby personally appears in this proceeding, and I could renounce guardianship of the property only, waive the issuance and service of process, and consent that Irini Bekhit be appointed the guardian of property of the above named infant. You always want to check off the right one, right? Because this form can be used for other things. So you want to make sure you fill in the appropriate thing. And that such relief is granted. He would have to sign. He would have to get that notarized. This would also be filled in if it's another parent. If it's a grandparent coming in, and the other grandparents are on the other side, they would also have to fill it. It's basically anybody who's on that same platform who has the same relationship to the infant. Everybody else has to consent to that relief. Affidavit of proposed guardian of the person is the next document. This is a document I, as the petitioner, have to complete because I am the proposed guardian. So again, I'm going to fill this in. I'm going to put in for Moses, State of New York, County of Richmond, Surrogate's Court, County of, as you can see, a lot of it is duplicitous. The undersigned, Irini Bekhit, being duly sworn, deposes and says, I'm a competent person over the age of 18, and I submit this affidavit in support of my petition to be appointed as guardian of the person of, you guessed it, Christopher Moses. It's not letting me put it in person of, but I guess it has a certain number of characteristics, but I'd fill that in completely. I have known the infant since birth by reason of I am his mother. I have always supported him and will continue to do so. So you want to put in why you actually want to be guardian. I reside at, you put in the address. Okay, and the other residents of the household are, this is important. Why? We use this information to determine who has to be fingerprinted. That's the other component of the background checks. I have to put in everybody in my household, where that, their names and their ages. So, or you can put in their date of birth. That might be better. We use this again as part of the background check. If I have grandma and grandpa that live with me, I would include their information here, okay? So you want to make sure that this is an accurate reflection of who lives in the household. Not including minor traffic offenses and adjudications as a youthful offender, wayward minor, or juvenile. I have never been convicted of an offense against the law except. You want to fill this in. You're not going to put in not applicable. You're going to put in none. So if you've never been convicted of anything here, you're going to put in none. I've never forwarded bail except none. I've not had any criminal except none. If you have had anything, if you had a DUI, or if you had, a physical assault altercation, when you were 18, 19, 20 years old, put it in. We're going to find out anyway when we do the background check. So it's important to disclose and explain. So if there's anything here that applies, just fill it in. Have a separate letter that explains the situation. That way the judge can kind of read it and make a determination as to whether or not you're fit to be a fiduciary or not. But it's always better to disclose. Again, I have no physical or mental impairment or medical condition which would interfere with my ability to perform the duties of guardian of the infant except none. We're not putting in not applicable. We're actually making that affirmative statement and saying there's nothing that's preventing me from acting in this capacity. I am not addicted to unlawful narcotics or alcohol. That's an affirmative statement. I am willing and able to undertake care, custody of my child until they reach 18 or until the court determines otherwise, also an affirmative statement. I believe that my appointment as guardian would be in the best interest of the infant for the following reasons. I am his mother. I have taken care of him since birth, and I have his best interest in mind. Okay, sign, notarize. Okay, next thing, affidavit of the parent. This is going to be signed if it is a parent who is not seeking to be guardian, or if it's a non-custodial parent, and they're relinquishing custody. So again, generally speaking, it's not an applicable document, but you would fill it in, just read it and fill it in if appropriate. So are you relinquishing, if you're a natural parent and you're relinquishing your right to this guardianship, you would fill this in. This is similar to the affidavit and waiver that we filled out before, but it is also different. It's specifically for the parent. The other one could be a parent, could be a grandparent. So again, this is specifically for the parent if they're relinquishing their right, not just waiving and consenting, okay? And that concludes that document that we have here. So when you get your package, it's going to be these documents, and you're going to fill in whatever is appropriate. It looks like everything I filled in. Okay, there it is. Some of it is still there. And then what are you going to do? You're going to print this out, go over it again. As you can see, there's a couple of things in the fillable document that I was not able to fill in. Review it again. And as a courtesy, due to COVID, you could email us the documents and we can review it. And then we can tell you if there's anything missing. Don't forget, you need to supply the 3909 form. So when we email you, you're going to get this document, but you're also going to get a mock 3909 form. And once that's also completed, we'll call you to schedule the fingerprint appointment. Let me just see here. And I'm going to now just spend a couple of minutes talking to you about the process so you know what to expect. When you file this document, you're going to file it with a $20 filing fee. You're going to also submit a certified or an original birth certificate, which you do not get back. You're also going to pay $6 for each certificate if you need it. So sometimes a financial institution will require a certificate of authority. Each certificate that you require is $6. So for my application here, it was for that bank, that life insurance policy, I would request one certificate. So my filing fee that I would pay is $20 plus 6 for a total of $26. So it would be that, it'd be the petition, everything that we just filled in with the appropriate documentation, as well as the 3909 form that has to be completed, and we would contact you for the fingerprint. If there are siblings who are above the age of 18, they also have to sign a waiver and consent. They also have to consent to the relief sought. So all interested parties have to sign a waiver and consent. And that's pretty much it. If there's any questions that you have, always contact us via email. That's really the best way to reach us. My email address is ibekhit, Bekhit @nycourts.gov. Or you can contact Alexandra Quinteros, who's also a member of the Guardianship Department. This is accurate information as of December of 2020. Don't know what's going to happen next year, but as of December 2020, this is still accurate information. I don't have Alex's email memorized, but if you email me or call the court, we'll give you our email address and you can kind of have it that way. Let me just stop sharing. And that's pretty much it. If you have any questions, always contact us, but this gives you a rough idea of what you have to submit. That way you can at least start the process. Once all the information is submitted, after we do our background checks, after you've been able to come in and be fingerprinted, we contact you to schedule the fingerprint appointment. After all that's done, everything is clear. A decision and order is drafted by the surrogate, and you're going to get emailed that decision and order, which appoints you as the guardian. And that's it. The decision is very detailed. It tells you about the process of what has to be done, about you contacting the bank directly to schedule the opening appointment. So once you get the decision order that makes you the guardian, what normally happens is you'll get that certificate, you get that decision. Now you go back to that insurance company or the financial institution that had the money. You show them that now you have the authority to get this information to actually open up the guardianship account. They send you a check titled as Irini Bekhit, guardian of the property of Christopher Moses, jointly held with the Richmond County Surrogates Court. That's going to be in the decision. It's part of your it's part of the directive that's given in there. So you get this check that's jointly held with you and the court. Then you can contact the bank. You open up the bank account, you give them whatever information they need, and now you have a jointly held guardianship account. You are not able to make any withdrawals as you see fit. You always have to contact the court if you need to make any withdrawals. So no withdrawals can be made without court approval. And as a general rule, we have certain documentations that we would require if you are seeking to get any money out for the infant child, because it is their money and it's supposed to be there for them until they reach the age of 18 or 21. But again, that's later on. You don't have to worry about that now. Right now, you just want to file your papers. And then the other thing is you're going to get an accountant. You're in a fiduciary status. You're in a fiduciary role. You are responsible for safeguarding those funds and making sure that you are kind of keeping on top of it. So every year you get an accounting form and you have to fill out that form and then you send it into the court that shows the money's in there. Here's an updated bank statement. Here's the interest that's accrued. This is what's going on. This is how much money my child has. And again, once they reach 18 or 21, they are able to get that money out. Okay. As always, if you have any questions, contact the court. The number for the surrogates court is 718-675-8500. And then you can ask to be transferred to the guardianship line, or you can always just send us an email. Thank you.